It's big news of the day, a day after the centre notified the fact-check unit under the Press Information Bureau to address, like they say, to address the challenge of fake news. The Supreme Court today has gone ahead and paused that notification, and it has been paused until the Bombay High Court decides on those pleas that challenge the constitutionality of this. To discuss this, we have two legal eagles with us on India Tonight to discuss the issues at stake around the fact-check unit and what the Supreme Court has said about it today. Aman Lekhi is a senior advocate of the Supreme Court of India, and Apar Gupta is an advocate of the law office of Apar Gupta. Apar Gupta, let me come to you first. The government, under the new amended IT rules, set upon itself that task to identify fake and false content on social media, and this pertains to anything, any content about the government. Within the amendment set up this fact-check unit, and this under the Press Information Bureau. Now that the Supreme Court has put a stay on it, how significant do you think it is that the Apex Court is pointing at constitutional issues of free speech and expression in this matter, much like the petitioners themselves?
So, I think what's more important than the substance of the finding, because there is actually not a substantive finding by the Supreme Court, it is that these rules were first created on April 6th of 2023, and there were about 11 undertakings given by the government that they would notify and constitute a fact-check unit which would operationalize this power of fact-checking. Okay. And then there was a decision of the Bombay High Court, which is a split decision. One judge says it's unconstitutional, one judge says it's constitutional. It goes to the third judge, and the third judge basically says that I'm not going to stay the operation of this rule because there is no fact-check unit right now. So that changed yesterday, because on March 20th, the government actually notified a fact-check unit and designated the Press Information Bureau as a fact-check unit. So I think the court, and it's been very careful, the Supreme Court has said that we are not commenting on the substance of the matter. There are constitutional issues which are arising here, but we don't want to prejudice the determination by the third judge of the Bombay High Court. Okay. And they are in their order are saying that we direct the stay of the March 20th notification of the constitution of the Press Information Bureau as the fact-check unit. So essentially what happens is that the government can't operationalize it till the matter is decided by the third judge in the Bombay High Court. So I think it is in some form of victory. In a lot of ways, it is a recognition that this is something significant and should not be done in haste.
Aman Lekhi, do you agree that in terms of the fundamental issue around what can be defined as false or fake or misleading, can the government be the arbiter of truth in that sense? What is this indicating to you?
Well, I'll put it slightly differently. Two aspects I want to flag. One, I personally feel that as far as the fact-check committee, constitution of the fact-check committee is concerned, before it operationalizes, the norms, the benchmark which it has to apply have to be settled. And because the challenge is pending to the rules, the method which the fact-check committee can actually invoke for the purposes of applying the law, that is 793, is still unsettled. And until that method is ascertained, the occasion for the fact-check committee to act in any manner whatsoever would not arise. So apart from the constitutional issues as a purely legal question, what the Supreme Court is actually saying is that await the outcome of the Bombay High Court, because the Bombay High Court is seized of the challenge to the rules, and the occasion for the fact-check committee to work has to await whatever finding the rules actually are held to imply in terms of the High Court order.
But Mr. Lekhi, that is, of course, the course of law. But when you talk about the intention of the government in this move, how do you read it?
Well, I personally think it's hasty and premature. There was no occasion for the government to have come up with this particular notification, more so because of the undertaking the government had actually given, and primarily so because that is, in a way, putting the cart before the horse, because before the rules are settled, the rules are to be applied. So this, as a method, is unwarranted, and therefore the Supreme Court has correctly stated. As far as the constitutional issues which you are mentioning are concerned, there's much to be said on both sides, particularly the occasion for the petitioner before the court, because as far as the operation of the relevant law, the 5 is concerned, the applicability to the petitioner is to some extent doubtful. But that said, the larger issue as to what the rules mean is still to be considered. And I personally feel that it was wholly unnecessary,
Right.
apart from being, in my opinion, hasty and both illegal
Yes.
for the government to have actually come out with this particular
Sure.
committee.
Apar Gupta, you have something to say about what Mr. Lekhi is hinting at?
Yes, so let me just add, I think it'll add some basis in terms of what I noticed immediately on April 6th, and I wrote about it,
Yes.
was that there was a lot of ambiguity which was there in the IT rules in terms of what was going to be checked as what is fake, false,
Right.
or misleading,
Right.
because these terms were not defined. And what also became a little much more concerning for me is that the power which is then directed towards social media platforms is towards censorship without even requiring the person who may be the author of the post, of the social media post, which may be a journalist or a person who has a YouTube channel, to be required to participate in a process of hearing in terms of a show cause notice, an opportunity of a defense, or a written order, which is even made public or transparent, because it impacts all of us as well, because that essentially is a comment of the government, and thereby citizens hold an interest in knowing that what the government is censoring about itself. So in a lot of ways, these procedural infirmities, I think, raised a high degree of suspicion from me that this process is liable to misuse, because it's essentially the government judging by itself what is fake, false, and misleading regarding any business
Correct.
of the central government. So history has shown
yes.
that these kind of censorship powers
Yes.
traditionally are misused, especially when they don't have procedural safeguards.
Right. But Apar Gupta, for content creators who put out pieces that are specifically political in nature on various social media platforms, what do you see as the legal checks and balances that would make India at par with other democracies in the world?
I think legal checks and balances are urgently required in different sectors of the digital ecosystem in India today. For instance, you have people who are selling all kinds of educational certifications online without any kind of oversight by the AICTE or the UGC. And here, I think regulatory bodies as well as the Advertising Standards Council play a very important role.
Right.
At the same time, I think just in terms of news reporting and journalistic standards, self-regulatory organizations, and even I think so independent regulatory bodies such as the Press Council can be looked at if they can play a role. But this kind of direct intervention by the government, especially with regard to reporting on itself, I think is actually an issue which does raise immediate constitutional concern.
Do you believe that the social media intermediaries that would otherwise seek safe harbor, which means they would get legal immunity against third-party content, will not get it if they don't pull down the content flagged off by the fact-check unit, if at all that happens, or prove the truth of such content, because the burden of truth is on these intermediaries, isn't it?
Is that for me?
Yes, Mr. Lekhi.
Well, just to add what has been said, one, keeping the political angle out and not premising whatever I'm saying basically on distrust, on the mechanics of law, what has to be seen is that these are rules in aid of a statute. And they put a very important question as to how is it that the environment to be regulated. I think the most important aspect of this is precision in expression, because precision in expression actually sets out the limits of application. And it is transgression of authority which is actually the cause of concern. So what I flag and actually highlight as the first requirement of an efficient regulatory mechanism is precision, where I feel the rules in question are lacking. And that is where one of the judges who has actually given a contrary opinion is, in my opinion, wrong, because he has actually relied upon the statute as a justification, omitting to notice the fact that when you have rules, you have to elaborate upon the broad content of the statute to narrow down on specific concerns which have to be addressed. It is here that this is lacking. As far as the method is concerned, in law, it's of course, as a preference, it should be heard, but post facto hearing is also in some way countenanced.
Right.
But those are procedural issues which we deal with later.
Right.
What I say and what I said at the outset itself is
Yes.
before you actually work, you have to know what you have to work on.
Right.
And that's where the existing regime is lacking.
Right. Well, while the Supreme Court has stayed the centre's notification on the fact-check unit, it has been stayed until the verdict comes in from the Bombay High Court, addressing various pleas that challenge the constitutionality of the fact-check unit. Meanwhile, this debate would rage on. And thanks so much for joining us with your legal opinions. Apar Gupta, Aman Lekhi, pleasure having you with us this evening on ET Now.